Welcome. Today we are mapping out the architecture of a trust receipt transaction under PD 115. This law was designed as a framework to assist merchants and importers with their financing problems through a convenient and legally secure business device. Let's look at how this structure is built. Sections 1 and 2 establish the core objectives and the legal framework for the entire decree. Here's a breakdown for the three main state policies outlined in Section 2. First, encouraging commerce. The state explicitly aims to promote trust receipts as a convenient aid to commerce and trade. Historically, the law was enacted because trust receipts had already become popular and a convenient business device to help importers and merchants to solve their financing problems, particularly in commercial banking. Next would be regulation and protection. So prior to PD 115, the Philippines lacked a special law, a specific law governing the rights and obligations of the parties in a trust receipt transaction, particularly regarding how to enforce those rights if someone defaulted. This is under Section 2-B. This addresses by formally regulating the transaction to ensure that the rights of both entrustor, the financier, and the entrustee, the merchant, are protected and their obligations are enforced. And lastly, criminalizing misuse. This provision gives the trust receipts law its strict enforcement power to explicitly declares that if an entrustee misuses or misappropriates the goods, documents, or the proceeds from their sale, it is not just a breach of contract, but a criminal offense. Specifically, such violations are punishable under the crime of estafa under Article 315 of the Revised Penal Code. Under Section 3 of the law defines the actors and outlines the legal mechanisms that drive their motivations. First, the entrustor. The entrustor is defined as a person who holds the title over the goods, documents, or instruments that are the subject of the trust receipt transaction, as well as any successor in interest. The motivation is the entrustor participates to provide financing while remaining protected. Their primary motivation is to establish a security interest. Section 3H explains that the entrustor takes or retains title even if it is expressed as an absolute title, specifically to secure performance of such obligations of the entrustee or some third persons to the entrustor. Next would be the entrustee. The entrustee is the person or their successor in interest who takes physical possession of the goods, documents, or instruments under the trust receipt. The motivation? The entrustee takes possession of the entrustor's property specifically for the purpose or purposes specified in the trust receipt agreement, while in Section 3 relies on the agreement to define the exact actions. The overarching motivation of this actor is to use trust receipt as a convenient business device to solve their financing problems. Lastly, the purchaser. The a purchaser is any person who takes items by purchase. So the motivation is the purchaser is the market participant motivated to acquire the goods or property. Under Section 3F, their method of acquisition is defined very broadly. It is not just a standard sale, but also includes taking by conditional sale, lease, mortgage, or pledge. So if you look at this, the person is broadly defined to ensure wide participation in these transactions. Section 3I defines a person broadly to include an individual, trustee, receiver, fiduciary, partnership, corporation, business trust, or two or more persons having a joint common interest, This ensures that the virtually any legal or business entity can act as an entrustor, entrustee, or a purchaser. Section 4 of the Trust Receipts Law, which is PD 115, establishes several bifurcation mechanics, branching path of rules depending on the type of property involved, the outcome of the transaction, and the inherent nature of the initial sale. Here is how Section 4 structurally bifurcates its mechanics. First, bifurcation of authorized purposes, goods, documents versus instruments. The law strictly splits what an entrustee is allowed to do with the entrusted property based on whether the item is a tangible good, document, or a financial instrument. So, path A, goods or documents. If the item are goods or documents of a title, the entrustee is authorized to sell them, to manufacture or process them for ultimate sale, and handle them in a way preliminary to sale, such as loading, unloading, or shipping. Notably, if the goods are delivered specifically for the manufacturing or processing, the mechanic dictates that the entrustor retains the title over the goods for both their original process forms until the entrustee's obligation is fulfilled. Path B, which is the instrument. So if the items are financial instruments, manufacturing or shipping does not apply. Instead, the entrustee is authorized to sell or exchange them, deliver them to a principal, use them to consummate a transaction requiring delivery for a depository or a register, or present them for collection or renewal. So the next one would be bifurcation of the entrustee's core obligation. So limit proceeds with return items. The fundamental mechanic of the trust receipt agreement splits it into two distinct operational outcomes, depending on whether the entrustee is successful in disposing of the items. So, if the goods, documents, or instruments are sold or otherwise disposed of, the entrustee must turn over the proceeds to the entrustor up to the amount owned. So the next one would be failure to sell. So if the items are unsold or not disposed of, the entrustee is obligated to return the specific goods, documents, or instruments themselves to the entrustor. Third would be a verification of coverage. So true trust receipts versus ordinary credit sales. So finally, Section 4 creates a jurisdictional bifurcation to distinguish genuine trust receipts transactions from ordinary sales. So, covered by the decree, a true trust receipt transaction involves a financier, entrustor, who releases goods to an entrustee strictly for the purposes of outlined above, supported by assigned trust receipts. So, outside of this decree, if a person is in the business of selling goods for profit, has general property rights against the buyer at the outset, and simply sells them on credit while retaining the title to secure the purchase price, this is considered an ordinary sale and falls entirely outside of the purview of the trust receipts law. Part 2 of section 4 establishes a clear boundary diagnostic to determine whether a transaction is legally regulated trust receipt or an ordinary credit sale. Here is how to diagnose which side of the boundary a transaction falls on. So, diagnostic 1, the trust receipt transaction inside the boundary. A transaction is governed by PD 115 if it is primarily a financing arrangement. It meets this criteria if an entrustor, typically a financier, who holds absolute title or a security interest over specified items, releases them to an entrustee. The entrustee signs a document binding themselves to hold the goods, documents, or instruments in trust The explicit obligation is to sell or dispose of the item and turn over the proceeds to the entrustor up to the amount owed, or to return the items if they remain unsold. So next would be the diagnostic 2, the ordinary credit sale outside the boundary. So section 4 expressly carves out ordinary credit sales, completely removing them from the purview of the coverage of the decree. A transaction crosses the boundary into an unregulated credit sale if it fits these specific characteristics. The seller's nature. The transaction is conducted by a person who is in the business of selling goods, documents, or instruments for profit. At the very outset of the transaction, the seller already has a general property rights in the goods as against the buyer. The seller is simply selling the items to the buyer on credit and is only retaining the title or other interest as security for the payment of the purchase price. The key boundary distinction: the ultimate diagnostic test depends on the origin of the property, rights, and the core nature of transaction. If a financier holds the title merely to facilitate the trustee's acquisition and subsequent sale of third party goods, it is a trust receipt. However, if a, regu- if a regular merchant already owns their inventory and simply sells it to a buyer on an installment or credit basis, holding onto the legal title until the buyer fully pays, this does not constitute a trust receipt transaction, and it cannot be prosecuted and enforced under this decree. The last part of Section 4 is called the transformation loop. So it occurs when goods or documents are entrusted not for the immediate sale, but specifically to manufacture or process the goods with the purpose of ultimate sale. So when goods enter this processing stage, their physical form changes, which could otherwise complicate ownership rights. So, however, the law provides a strict continuous safeguard to the financier. The entrustor retains its title over the goods, whether in their original or processed form. This means that even as a raw material are transformed into finished product by the entrustee, the entrustor's security interest perfectly tracks that transformation. This retention of title remains completely intact until the entrustee has fully complied with his obligation under the trust receipt. Section 5 of PD 115 outlines the legal requirements for the form and contents of trust receipt. Flexibility in form. The law provides flexibility regarding the physical appearance or template of the document, expressly stating that the trust receipt does not need to be in any particular form. Mandatory contents. Despite this flexibility in form, the law dictates that every trust receipt must substantially contain three core elements to be valid: a clear description of the specific goods, documents, or instrument that are the subject of the trust receipt, the total invoice value of the goods, and the specific amount of the draft to be paid by the entrustee, and a formal undertaking from the entrustee explicitly stating their obligation to hold the prescribed items in trust for the entrustor, dispose of them in the manner specifically provided for in the receipt, turn over the proceeds of the sale to the entrustor at up to the amount owed, or return the items in the event that they are not sold within the specified period. So, additional terms and conditions. The law also allows the parties to customize their agreement. The trust receipt may include other terms and conditions upon by the entrustor and entrustee. However, the inclusion of these extra provisions is subject to vital limitation. They must not be contrary to the provisions of the decree, existing laws, public policy, and moral public order, or good customs. Section 6 of the Trust Receipt Law, PD 115, governs the currency in which a trust receipt may be denominated, which is particularly important for importers dealing with international trade. So, allowable currencies. The law provides uh, financial flexibility by allowing a trust receipt to be denominated in either Philippine currency or any foreign currency that is acceptable and eligible as part of the international reserves of the Philippines. This allowance stands regardless of any existing laws, executive order, or regulations that might otherwise state the contrary. So, rules for foreign currency payments to establish a clear standard for settling obligations. Section 6 provides a specific rule for trust receipt denominated in a foreign currency. In this instance, the actual payment turned over to the entrustor must be made in its equivalent in Philippine currency. So, computing the exchange rate, the law also dictates exactly how to calculate that equivalent value to avoid disputes over fluctuating currency values. The foreign currency must be computed at the prevailing exchange rate on the exact date the proceeds of the sale are turned over to the entrustor. However, a law respects mutual agreement. The parties can use exchange rate from different date if they explicitly stipulate that date in the trust receipt or in another executed agreement. In this slide, we'll be combining section 7 and 9 of PD 115. Act as two sides of the same coin, outlining the powerful rights granted to the financier, the entrustor, and the strict corresponding duties placed upon the merchant or importer, the entrustee. Here's the breakdown of these two critical provisions. So, Section 7, the rights and protection of the entrustor. Section 7 heavily protects the entrustor's investment, giving them absolute priority over the entrusted item and clear remedies if the agreement is breached. Right to proceeds or return. The entrustor is fundamentally entitled to the proceeds of the sale of the goods, documents, or instruments up to the amount they are owed. If the items are not sold, they have the right to demand their return. So, right to cancel and retake upon default. If the entrustee defaults or fails to comply with any terms, the entrustor can immediately cancel the trust and take physical possession of the goods, documents, or realized proceeds. The right to sell the retaken goods. So, once in possession after a default, the entrustor has the right to sell the items at a public or private sale. They must give the entrustee at least 5 days written notice, either personally served or mailed. Before so, the entrustor is even allowed to be the purchaser if it is a public sale. So the application of the sale of the proceeds, if a default sale occurs, the money is strictly applied in this order. A. Paying the expenses of the sale itself. B. Covering the cost of retaking, keeping, and storing the items. And C. Satisfying the entrustee's actual debt. So, with regards to surplus and deficiency, if there is money left over after the debt and the expenses are paid, the surplus must be given to the entrustee. However, if the sale does not cover the full debt, the entrustee remains legally liable to the entrustor for the deficiency. So we go to section 9. The obligations of the entrustee to balance the entrustor's rights. Section 9 imposes a strict 6-point checklist of duties that the entrustee must follow while in possession of the property. Hold and dispose strictly. The entrustee must hold the items in trust and dispose of them exactly as dictated by the terms and conditions of the trust receipt. Turn over proceeds. They must receive all sale proceeds in trust and promptly turn them over to the entrustor up to the amount owed. Insure the goods. The entrustee is required to insure the goods for their total value to protect against loss from fire, theft, pilferage, and other casualties. Segregate the property, whether holding the physical goods or the money from the sale. The entrustee must keep them entirely separate and capable of being clearly identified as the entrustor's property. And return unsold goods. If the items are not sold, or if the entrustor simply demands it, the entrustee must return the goods, documents, or instruments, and observe all conditions. The entrustee must follow all agreed upon terms provided they are not contrary to the provisions of the decree. So, we again combined sections 8 and 10 uh, with regards to PD 115. So, define the boundaries of liability and the strict allocation of risk between the financier, the entrustor, and the merchant, the entrustee. So, Section 8, the entrustor's shield against third party liability. Section 8 specifically protects the entrustor from being held legally responsible for the subsequent business dealings of the entrustee. It dictates that even though the entrustor holds a security interest and has explicitly given the entrustee the liberty to sell or dispose of the entrusted items, the entrustor shall not be responsible as a principal or vendor under any sale or any contract to sell made by the entrustee. This provision provides a vital legal shield for banks and financiers. It ensures that if a third party purchaser has an issue with the goods, such as a product defect or a breach of warranty, they cannot sue the bank that merely financed the transaction. The entrustor's role remains strictly that of a secured creditor, insulating them from operational liabilities of merchandising. So we go to section 10, the entrustee's absolute risk of loss. So section 10 establishes the uncompromising rule regarding the physical safety of the entrusted items. The risk of loss shall be borne entirely by the entrustee. If the goods, documents, or instruments are lost while pending disposition, the entrustee's financial obligations to pay the entrustor for their value is not extinguished. So the law makes this liability absolute by explicitly stating that the entrustee remains liable irrespective of whether or not the loss was due to the fault or negligence of the entrustee. This means that even in cases of unavoidable accidents, natural disaster, or theft, where the merchant did nothing wrong, they must still pay the financier the full value of the lost items. This strict allocation of risk is precisely why Section 9 inherently requires the entrustee to insure the goods for their total value against fire, theft, pilferage, and other casualties, ensuring entrustors' financial interest is never left unprotected. We go to Section 12 of PD 115. It establishes a powerful legal shield for the financier by affirming the validity of the entrustor's security interest against any other creditors. Specifically, the law dictates that the entrustor's security interest in the goods, documents, or instruments as laid out in the written terms of the trust receipt shall be valid against all creditors of the entrustee. Furthermore, this protection remains firmly in place for the entire duration of the trust receipt agreement. What this means in practice: if a merchant or importer, the entrustee, encounters financial difficulties, falls into bankruptcy, or owes money to the other parties, those general creditors cannot seize or lay claim to the goods covered by the trust receipt to satisfy their debts. Because the entrustor's security interest is legally prioritized, their claim over the entrusted property remains fully protected against the entrustee's outside financial liabilities. So, Section 11 of PD 115 also addresses the rights of the purchaser for the value in good faith, serving a crucial counterbalance to the entrustor's powerful security interest. So, protections of the open market. While the law strongly protects the financier, the entrustor against the merchant's general creditors, it must also protect the everyday flow of commerce. Section 11 dictates that if a purchaser buys goods from an entrustee who has the right to sell them or acquires documents or instruments through customary transfer, they acquire those items completely free from the entrustor's security interest. The two requirements for protection for third-party buyer to successfully sever the entrustor's legal claim over the items, the purchase must meet two specific conditions. One, for value. The the purchaser must give sufficient legal consideration, such as paying the purchase price for the goods, documents, or instruments. Uh, and two, in good faith. The buyer must make the purchase innocently without any intent to defraud the entrustor or circumvent the trust receipt agreement. So this provision is essentially for retail and trade to function smoothly. It ensures that an ordinary customer walking into a store or business does not need to worry about whether the merchant's inventory is financed through trust receipt. As long as the customer buys the goods in good faith and pays them, the bank or financier cannot later repossess those goods for from the customer if the merchant defaults on their financing agreement. So, under Section 7 of PD 115, the law provides the entrustor with a clear step by step legal mechanism to recover their investment if the entrustee defaults on the agreement. Here is how the mechanics of the repossession and sale work. So, step 1, cancellation and repossession. If the entrustee defaults or fails to comply with any terms and conditions of the trust receipt, the entrustor has the right to cancel their trust at any time. Once cancelled, the entrustor can immediately take physical possession of the goods, documents, instruments, or any proceeds that have already been realized. So, step 2, notice of intention to sell. After taking possession of the defaulted items, the entrustor has the option to sell them to recover their funds. However, they must first give the entrustee written notice of their intention to sell. This notice is considered legally sufficient if it is either personally served to the entrustee or sent via postpaid ordinary mail to the entrustee's last known business address. Step 3, the mandatory waiting period in sale. The entrustor must wait not less than 5 days after serving or sending the notice before they can actually execute the sale. When the sale occurs, the entrustor has the flexibility to conduct either a public or private sale. Notably, if they opt for a public sale, the entrustor is legally allowed to become the purchaser of the goods themselves. So, step 4, strict application of the sale proceeds. The money generated from the sale cannot simply be pocketed by the entrustor. The law dictates it must be applied in a strict prioritized order. First, to pay the expenses of the sale itself. Second, to pay the expenses incurred for retaking, keeping, and storing the goods, documents, and instruments. Third, to satisfy the actual indebtedness that the entrustee owes to the entrustor. So, the last step actually is handling the surplus and deficiency. The final mechanic addresses the remaining balance after the sale proceeds are applied. So, if the sale generates more money than is needed to cover the expenses and debt, the entrustee is entitled to receive any surplus. On the other hand, if the sale does not generate enough money to cover the total amount owed, the entrustee remains completely liable for the entrustor for any deficiency. So this is the exciting part. So Section 13 of PD 115 acts as the ultimate criminal trapdoor of the decree, transforming what might otherwise look like a simple breach of contract into a severe criminal offense. Here is how the trapdoor operates. The trigger, failure to remit or return the trapdoor is triggered when the entrustee violates their most fundamental obligation under the trust receipt agreement, specifically if the entrustee fails to return over the proceeds of the sale up to the amount owed or fails to return the goods, documents, or instruments if they remain unsold or undisposed of. They fall through this legal trapdoor. The crime, estafa. Once triggered, the law dictates that this failure is not merely a civil dispute over the unpaid debt. It legally constitutes the crime of estafa. The offender is prosecuted and punishable under the strict provisions of Article 315, paragraph 1b of the Revised Penal Code. This is the exact mechanism that fulfills the state's policy to penalize the misuse and misappropriation of finance goods. So, piercing the corporate shield, one of the most powerful aspects of Section 13 is how it handles corporate violators. If the offense is committed by a corporation, partnership, association, and other juridical entity, the law does not allow the individuals involved to hide behind the corporate veil. Instead, the criminal penalty is imposed directly upon the directors, officers, employees, or other officials or persons responsible for the offense. There is also what we call a dual liability. Finally, falling through this criminal trapdoor does not erase the original financial obligation. The law explicitly states that holding these individuals criminally liable for estafa is without prejudice to the civil liabilities arising from the criminal offense. This means that the responsible individuals may face imprisonment while still being legally required to pay back the financier. So Section 7 and 13 of the Trust Receipt Law, PD 115, work in tandem to create a formidable dual threat against defaulting merchants or importers by combining strict civil restitution with severe criminal penalties. The law ensures that a breach of a trust receipt agreement cannot be treated as a mere cost of doing business. Here's how this dual threat operates. So the first threat, civil restitution under Section 7. Section 7 is designed to guarantee that the financier, the entrustor, recovers their financial investment. If the entrustee defaults on their obligation, the entrustor has immediate right to cancel the trust and physical possession of the goods, documents, instruments, or any realized proceeds. To achieve full restitution, the entrustor can sell the repossessed items at a public or private sale after giving a 5-day written notice. The proceeds of this sale are strictly applied to the expenses of the sale itself, the cost of retaking, keeping, and storing the goods, and the actual indebtedness of the entrustee. Crucially, if the sale does not generate enough money to cover the debt and all associated expenses, the law dictates that the entrustee remain fully liable to the entrustor for any deficiency. This ensures entrustor's civil rights to be made completely whole. So the second threat would be criminal liability under Section 13, while Section 7 handles the financial recovery. Section 13 introduces the criminal chapter we discussed earlier. If the entrustee fails in their fundamental duty to either turn over the proceeds of the sale or return the unsold goods, this failure legally constitutes the crime of staffa, punishable under the revised penal code. Furthermore, the law pierces the corporate veil if a corporation commits this violation. The director, officers, and employees responsible for the offense are the ones who will face criminal penalty. So the intersection, without prejudice, the true power of the dual threat lies on the final clause of Section 13. So the sources explicitly state that the prosecuting the responsible parties of for staffa is without prejudice to the civil liabilities arising from the criminal offense. This means that the remedies are mutually exclusive. The entrustee cannot escape their financial debt by serving jail time, nor can they automatically avoid criminal prosecution simply by eventually paying the deficiency after the prolonged default. The entrustor is empowered to pursue both civil restitution of their money under Section 7 and the criminal prosecution of the entrustee for staffa under Section 13. So we go to the last slide, which is Section 14 to 17. These final four sections provide the standard statutory framework to ensure the law operates smoothly alongside the broader legal system. So Section 14, supplementary laws. This provision acts as a legal fallback, stating that any cases or situations not specifically provided within the decree itself shall be governed by the applicable provisions of existing laws. Section 15, separability clause. This is a standard statutory safeguard ensuring that if any specific provisions or sections of the decree or its application to a particular person or circumstance is held to be invalid, the remaining provisions will not be affected and will continue in full force. So Section 16, repealing clause, to ensure the trust receipt law takes precedence over older conflicting rules, this section mandates that all acts inconsistent with this decree are explicitly repealed. And lastly, the effectivity. Finally, this section also establishes the timeline of the law, stating that the decree took effect immediately upon its signing last January 29, 1973. Thank you very much for listening and for the explanation under PD 115.